Substitute decision-making is a generic term that is applied to various types of legal authority that confer the power on one person to make binding financial, health care, or other decisions for another person. These include guardianship, financial powers of attorney, health care advance directives, mental health care advance directives, health care representatives, representative payees, and trusts. Substitute decision-making is sometimes called surrogate decision-making, and the people who have the authority to make decisions for other individuals are generally called surrogates. You are watching one in a series of videos on substitute decision-making by the Disability Rights Network of Pennsylvania and the Developmental Disabilities Council. The people who appear in these videos are individuals with disabilities, family members, and advocates who are interested in and impacted by these issues. This video addresses common questions relating to trusts and estate planning for individuals with disabilities. Okay, we're going to get started. Thank you all for coming. My name is Mark Murphy. I'm an attorney with the Disability Rights Network of Pennsylvania, and I'm here to try to answer your questions about trusts and how trusts can benefit people with disabilities and how they can be set up and established by family members of people with disabilities. So I hope you brought questions because I'm here to answer them, and why don't we get started? Who wants to ask the first one?
I have a daughter, an adult daughter with a very serious, very significant intellectual disabilities. We also have two other children, two boys. We do not have a lot of money. We're still paying the mortgage to the bank. Should we get a will?
Yes, everyone should have a will. Whether you had a family member with a disability or not, it's important to have a will as part of an overall estate planning process that you can use. And estate planning is really just a fancy term for a series of decisions that you can make to determine what happens to your property, your money, after you've died. And so it's important to have a will for all of us because if you have a will, you get to decide what happens to your money, to your property, where you want it to go. Some people want to donate to charity. Some people want to donate to their church. Some people want to give all their money to their children. Some people want to give less money to their children. You get to decide under a will. And that's why it's important for all of us to have wills so we can make these types of decisions. In your case, as a parent of somebody with a disability, particularly somebody who might not be able to manage money, it's important in your will to make decisions that don't jeopardize any benefits that she may have. A number of benefits that people with disability get, such as supplemental security income, or SSI, that's a monthly cash benefit, and then the medical assistance, which pays for medical care and also pays for other types of services that people with intellectual disabilities get, for example. Those benefits are mean tested, and that means that you can't have more than a certain amount of money to be eligible. So if you go over certain limits, and they're pretty low limits, then the person, in this case your daughter, would be disqualified. And that's what you pretty much want to avoid. And so by being careful in your will and having a will, you get to make sure those decisions are made properly. If you don't have a will, then what happens is the state, in fact, has a formula, and money and your property would just go to your daughter and any other children you have in a predetermined formula. And that may be not what you want, because that may put her over those limits. So that's why it's important for you to know how much money you can give to your daughter and in what form, and therefore you'll be able to make sure that the benefits remain intact.
Now, how can I make sure that my daughter will have enough money, enough resources after I die and not jeopardize her government benefits?
Well, a good way to do that is a trust. And what a trust does is allow you to set up, through a legal instrument, a mechanism by which property can be managed, generate income, and then the income for that money can be used to benefit, in this case, your daughter. So let me talk about the elements of a trust, because a lot of people don't understand what a trust is and how you make it up. There are essentially four elements that we need to talk about. The first is somebody who is called the grantor. In this case, that would be you as the parent, the person who has the money or the property, decides to set up a trust through a trust agreement. And that trust agreement is a written document, and it sets forth what the property or money is, how you want it invested, how you want it used for. In your case, it might be to take care of certain expenses for your daughter. So it's your set of instructions about how the money can be used. You then have a trustee, and the trustee is a third party who actually does have the legal possession of the money, and makes decisions about, under the document that you've created, makes the decisions about how that money will be spent and has to follow your instructions. So they can't just do anything they want, they have to follow your instructions. And then finally, there's a beneficiary, and that would be your daughter, the person for whom the trust has been set up and who gets the benefit of whatever income is generated by the trust. So you have the grantor sets up a trust agreement, naming a trustee for the benefit of the beneficiary, in this case, your daughter. So that's what a trust is in its most basic sense.
Are there different kinds of trust?
There are. There can be used for any wide range of things. We're talking about trusts that help people with disabilities, but even in that sense, there are different elements to a trust. So for example, a trust can be sometimes called a third-party trust, and that means, in this case, you would set it up for the benefit of somebody else. So for example, in the last example, as a parent of somebody with a disability, it's the parent's assets that are used to set up the trust. That's what makes it a third-party trust, because it's the beneficiary benefit of somebody else. They're also called first-party trusts, and that means you would be using your own assets, your own money, your own property to set up a trust to benefit yourself. So you can have a third-party trust or a first-party trust. Trusts can also be mandatory or discretionary. And mandatory means that the trust requires that certain payments are made at certain times or certain things must be done along a schedule that's set up. And discretionary trust is something that the trustee looks at the overall circumstances and has the discretion to decide when to pay out money, how much money to pay out, etc. For our purposes, talking about trusts that benefit people with disabilities, you almost always are going to want a discretionary trust. And then finally, trusts can be revocable or irrevocable. Revocable means that the person setting up the trust, the grantor, in our earlier example, the parent, can at some point decide to take the trust back and take the property back and dissolve the trust. Irrevocable means once the trust is set up, that property or money is gone from the parent forever. And again, in the context of setting up trusts for people with disabilities, you almost always want an irrevocable trust. So we'll talk about some of these things as we move forward. But again, mandatory, discretionary, almost always going to want discretionary. Revocable or irrevocable, you're almost always going to want irrevocable.
What kind of trust can I create to keep my daughter's benefits?
Well, there are trusts come with different names, but basically when we're talking about trusts for that act for the benefit of people with disabilities, they're usually gone by the term supplemental needs trusts. And so that kind of trust can be set up, and if those are designed properly, then the money or other income that comes out of those trusts won't disqualify the person with the disability from benefits. And so you're going to want to do what's called a supplemental needs trust.
What federal rules are there to allow my daughter to keep her benefits?
Well, that's a great question, because there are a lot of different rules, and you have to make sure you meet them all, because you don't want your daughter disqualified from getting SSI benefits. And so let's talk about what the Social Security Administration wants to see in a trust to make sure that SSI benefits are not jeopardized. The trust is looked at for two things. One, you have to make sure that the resources and the income don't exceed allowable limits. And so the resources would be what is owned by the trust and any other resources that your daughter might have. And so it's important that the resources not exceed the limits, and it's important that any income from the trust and any other sources not exceed the limits. And so as long as the trust, on the resource side, as long as the trust is discretionary and irrevocable, then that'll satisfy the Social Security Administration as to the resource side of things. On the income side of things, the money that the trust generates can only be used in certain ways, or else it'll jeopardize the SSI benefits. So for example, the trust income can't be used as a direct cash payment to your daughter with a disability. So you can't give a direct cash payment, and you can't use any of the income to pay somebody else for food or shelter. So no cash directly and no food or shelter. However, somebody else, the trustee or third party, can pay someone else to pay for other expenses, medical expenses, education expenses, recreation expenses. As long as it's not food or shelter, the money can be used. That'll satisfy the Social Security Administration, and it won't jeopardize the SSI benefits.
Are there any state rules I should be concerned about?
Also a really good question, because it's not enough just to satisfy the Social Security Administration. You also have to satisfy the state of Pennsylvania. They administer the Medical Assistance Program, which pays for a lot of health care and other services for people with disabilities, and so they have eligibility rules too. So they want to make sure that there's not too much income coming to the person with a disability, which would make them disqualified for those benefits. And so you're generally going to be okay with your trust if it contains several different elements. And these elements are drawn from cases that courts have decided rather than statutes like the Social Security Administration or regulations. And so they're a little less clear, and they sometimes are subject to change. But here's what we know so far from these cases. There are basically 4 things you have to demonstrate that your trust does. First, you want a clear statement that the trust is designed to supplement, not supplant, what the person is already getting from the government, the benefits they're getting. So again, it's important. We call it a supplemental needs trust. So it's important that it supplement, not supplant, the benefits the person is already getting, and that should be written right into the trust itself. Secondly, the individual with the disability shouldn't be the sole beneficiary, should not be the sole beneficiary. That's different from the federal side because it's a third-party trust. And so what happens is you might name other children as a possible beneficiary, and you leave it to the trustee to decide in its discretion whether or not to give money to your child with a disability versus somebody else. They have to have that discretion. And so the third element is the absolute discretion of the trustee. Once you turn over the money, you can't control where the money goes. Remember earlier I said you don't want it to be mandatory, you want it to be discretionary. So it's important that it be discretionary. And then finally, you want to make it clear that in the trust that the individual with a disability has already been receiving benefits from the government, medical assistance benefits, supplemental security income, and therefore you're trying to maintain those benefits and not disqualify them. It's really important that you show what your intent is, and that's why it's important to make clear that in the trust that your son or daughter has been getting prior benefits, and so therefore you're trying to protect what they've already been getting.
How should I choose a trustee?
Well, that's another great question, because we get that question a lot because people often have trouble knowing who should be the trustee, what the trustee has to do, how do you find a trustee. And basically what's important in a trustee is that you find somebody who's willing to make a commitment to your family member, to their well-being, to making sure that the trust is followed and it's going to benefit your son or daughter. And so what you can do is oftentimes find a family member willing to do this. Sometimes you can get a friend who might be willing to do it. Remember, this all takes place after you've died, and so you have to keep in mind that you're not going to be around to necessarily oversee all this, particularly if you do it through estate planning. And so in addition to a family member or close friend, sometimes people get professional trustees. If you have enough money, a bank will do it, but they generally will require a lot of money, and maybe you're lucky enough to have a lot of money. But if you do, a bank may do it, though of course they'll charge a fee. So if you're looking at professional trustees, you want to compare fees the way you would if you were shopping for any kind of service. But the most common thing, at least on some of these supplemental needs trusts, is other family members, oftentimes siblings of the individual with a disability, or somebody who knows the person well and knows what they need and knows what how they would benefit. And of course, you're going to let them know that through the trust document as well. So it's not always that easy to find a trustee, and you just have to find someone you're comfortable with who you think will carry out the wishes of the trust in a way that you'd be satisfied with.
Our teenage son was in an accident and he has a traumatic brain injury. He receives SSI and has medical assistance. We filed a lawsuit on his behalf. If he receives a judgment or a settlement, is that going to jeopardize his benefits?
Well, that's a good question too, because that situation often comes up. And yes, you should be concerned, but there's a way to deal with it. And so remember, you should always be concerned if the person with a disability who's getting these benefits, MA or SSI, has access to income or money, because that can be disqualifying. So the question is, how can we make it so it isn't disqualifying? And fortunately, what can happen is the creation of what's known as a first-party trust, in which the individual involved can in fact set up a trust with their own assets, and if it's done properly, then there's not a disqualification of the benefits. It's important to keep in mind, however, depending on the individual situation, that a trust may not be the answer. Suppose there's either through a settlement or judgment, there's a tremendous amount of money, as is sometimes the case, unfortunately, because that usually means someone has been maybe badly injured. But it may be so much money that you can pay for a lot of things yourself, and you may want to do that, and rather than just deal with what MA provides. On the other side of things, it may be a relatively small amount of money, and you might be better off simply spending it in the way you would like to spend it, and the person may not get benefits for a while, but then they can always get their benefits restored. So you shouldn't automatically assume that regardless of the amount of money, a trust is the answer. It's going to be the best approach in, I think, the majority of cases, but it either sort of not that much money, in which case you just want to spend it for so the person has whatever they want, and if that means you lose a few months of benefits, that might be okay. Or on the high end, it may be so much money that it doesn't make sense to sort of limit yourself to the $600 or $700 that you get under SSI and some of the MA benefits. So you have to look at the whole picture. So just don't assume that a trust is always the right approach.
If we do use a trust, what kind of trusts are available to protect our son from losing his benefits?
There are two kinds of trusts that can be set up when the person himself or herself, in this case your son, has money or property of their own rather than being given by a third party such as another family member. And so those are called a payback trust, and the other is called a pooled trust.
What is a payback trust?
A payback trust is a type of trust that can't be set up by the individual. It has to be set up by, even though it's their property, it has to be set up by a parent, a grandparent. So the individual himself or herself doesn't set up the trust. But it's set up in such a way that the money is then used for the benefit of the person, as I've described before. And that person has to be the sole beneficiary of that trust, and that trust has to be irrevocable. And if those two tests are met, then it'll be okay. And the reason they call it a payback trust is that because when the trust ends, if the person dies, for example, and the trust ends, any money that's left in the trust has to be paid back to the medical assistance program in the state that has been paying the person's bills. Remember, it's being used to keep you eligible for medical assistance and other programs. And so it's called a payback trust because if the person doesn't use up all the resources in the trust, whatever's left has to be paid back to the state into their medical assistance program.
What is a pooled trust?
A pooled trust is a slightly different type of trust in which that can be set up by the individual or a third party, such as a parent, and it's usually run by a nonprofit corporation. And it's really a neat way to help people, particularly if they don't have a lot of resources in their trust, people with smaller types of trusts. And so what happens is your trust gets its own account. It's placed in trust with the nonprofit corporation that manages it. And what happens is, for investment and management purposes, all the money is pooled together, and that's why they call it a pooled trust. And so you may have, for example, $30,000 in your trust, and I may have $1 million in my trust. And so you get all these people together, and so you pool that money together, and that way you can manage it and invest it more effectively. And at the end of the trust, what happens is if the person who's the beneficiary dies and there's money left in their account, that money has to go into the pool, and it's used for the benefit of all the other people who are in the pool. So that's why it's called a pooled trust as opposed to the payback trust. You don't necessarily have to pay it back to the MA people, though you can, and I'm sure they would take the money. But you can keep it in the pool, and then it's used for the benefit of other people. So it's just a different type of trust that can be set up.
This sounds pretty complicated. Do we need a lawyer?
Many people do get a lawyer, and it's a really good idea to make sure you're at least talking to somebody who has experience in this area. In many cases, that will be a lawyer. Some of these nonprofit corporations that I just mentioned also have a lot of experience at this, obviously, and they can provide you with advice. But when you're actually setting up the trust itself, particularly if it's part of your overall estate plan, which would include a will and some other documents, then you really should see a lawyer who has specific experience in creating trusts that benefit people with disabilities. It's important that you do this properly. As you know, having heard all the various elements and the various rules that are here, some are federal and some are state, this is not something that you can sort of be careless about. You have to make sure you're talking to somebody who knows what they're doing in this area. So it's really important. And you can contact the Disability Rights Network. We can sometimes refer you to somebody. Some of these organizations that run pool trusts, those nonprofit corporations, they also have the ability to refer you to lawyers who have experience in this area, so you could try them as well. Either is a good option to get a referral for this area. Okay, I think I've answered all your questions, I hope, anyway, and I hope you're leaving with more information than you had, and I really appreciate you coming, and thank you very much. If you have additional questions or need more information about trusts or other types of substitute decision-making, please visit our website at www.drnpa.org to access DRN's guide, Consent, Capacity, and Substitute Decision-Making, as well as other videos in this series.